Welcome. The Vancouver chapter of Dying with Dignity Canada is so pleased that you could join us this evening. My name is Sue Hughson. I'm on the board of directors of Dying with Dignity Canada and a member of our local chapter administration. Dying with Dignity Canada has been around since the 1980s. We are the go-to national organization for medical assistance in dying-related issues, and we are for you, the citizens. We are dedicated to expanding end-of-life choice, providing information and education about medical assistance in dying, and helping to prevent unwanted suffering for all Canadians. Before I introduce our truly amazing speakers for this evening, I want to thank all of the people I see before me who have been personally involved with MAiD, Dying with Dignity Canada, the BC Civil Liberties Association, or C, all of the above. Carter may be one of the country's most important constitutional cases, but end-of-life choice happens at the grassroots, in community, here, with you and for you. So as the second anniversary of C14 approaches, who better to tell us where we are and where we must go than Aubrey, Dr. Wiebe, and Shanaaz Gokool. Jay is a litigator with the BC Civil Liberties Association. She's a graduate of Osgoode Hall's Law School Criminal Intensive Program. She also has a master's degree in women's studies and feminist research. I'm going to abbreviate the rest of her excellent bio to say that she is a prize-winning fierce force of good. You can have it. Jay, if we could start with you, that would be fantastic.
Just a brief overview. We're going to talk about the complete prohibition era, where we had a complete criminal prohibition on all forms of assisted dying. Then we're going to talk about the legalization of assisted dying briefly with the Carter victory, which happened in 2015 and was implemented in 2016. And then we're going to talk about the current context, which we refer to as a partial prohibition, because a whole category of people who were granted a right under Carter have been denied that right by Bill C14, which was the government's sort of half-done response to Carter. And then ultimately I'm going to end with outlining for you folks the Lamb Challenge, which is BCCLA and Julia Lamb's follow-up to the Carter Challenge, really just trying to re-establish the right that was already given to Canadians in Carter. So it's for everybody that's left out under Bill C14 as the ongoing litigation in front of the BC Supreme Court, which is the Lamb Challenge. So BC Civil Liberties Association is my employer, and I'm really lucky to be here. I get to be a litigator, as Sue said, and in that role, I take a lot of calls from sick and suffering Canadians who are suffering unbearably, who are trapped and who don't have any options. Some of these folks have already ended their lives because they weren't granted a medically assisted death. They weren't eligible under Bill C14 or the laws created by it. These are the people that are left out, and so they inform all parts of the work that we're doing as we move forward on this issue. So I just want to emphasize that the assisted dying movement really built the social context on which the legal gains could be made. So, we can go back to Sue Rodriguez and people before Sue who really fought to change and really turn the tide of public opinion around medically assisted dying, and none of the legal work would have been possible without that social change. So it really does speak to the power of grassroots movements, and for you folks for all being invested in this issue and being here tonight. Unfortunately, Sue, as much suffering as she was in, was not able to strike down the law. A brave doctor did step up nonetheless. Again, power of the people. But Sue, when she was at the Supreme Court split 5-4. And they said, Sue, yep, your Section 7 charter right to security of your person is being violated. But Section 7 only protects your life, liberty, and security of the person insofar as it's not a breach of principles of fundamental justice. So you're only allowed you can be deprived of those rights as long as the government can prove that it's in accordance with the principles of fundamental justice. And the court, when they were looking at Sue Rodriguez's case, said, well, principles of fundamental justice imply some type of consensus from society that the principles vital or fundamental to society's notion of justice. So it's a very kind of general, sort of loose language. And they said there's a societal consensus here that human life is worth preserving in all contexts. And so the government's objective of doing that here is going to be in line with the principles of fundamental justice, such that we can take away the life, liberty, or security of person of certain individuals. And so they said, well, Sue, you're suffering terribly, but it's not enough because there's a societal consensus that this is okay, that we can't condone the taking of life in any context. In 2011, BCCLA and a couple individuals filed a challenge to the same criminal code sections that Sue Rodriguez had filed the challenge to, based on the belief that the right to control when and how we die is integral to the life, liberty, and security of person of all suffering and ill Canadians. So we had three women who really led the charge. Gloria Taylor, who's pictured here. I don't think she would mind me referring to her as a motorcycle babe, because that's exactly what she was. She was a really independent, powerful woman. She died when she was 64, and she had ALS. She experienced progressive paralysis throughout her life, or throughout her later years. And this is a quote from Gloria. She says, "I now have different strangers assist me with showering every day, something I experience as an assault, not only on my privacy, but on my dignity and my self-esteem. What I fear is a death that negates, as opposed to concludes, my life. It is important to me that my family has final memories that capture me as I really am, not as someone I can't identify with and have no desire to become." Another woman who led the case through her memory, actually, through her two children, was Kay Carter, who the case is named after. Severe spinal stenosis. She was 89 when she passed. She traveled to Switzerland to pass with medical assistance, and her children attended the trial and were named plaintiffs because they were potentially subject to criminal prosecution for having traveled with her. So this is a quote from Lee Carter, Kay's daughter. She says, "The stress and the uncertainty about whether Kay would have been able to make the trip, given the state of her health, often preoccupied Kay's thinking, and I felt cheated of precious time that we might otherwise have spent saying our goodbyes in a more relaxed atmosphere." And Elaine Chapray is a third woman. I don't have her picture here today, but she had MS. Which is the condition that Julia Lamb has, our current plaintiff. And she passed when she was 69 with medical assistance. She had a non-terminal condition, as I said, same as Julia Lamb. Can lead to total paralysis and the inability to breathe, eat, and speak. And Elaine described her positioning. She said, "I am essentially a prisoner in my own body." So on the strength of these folks' evidence, we challenged the criminal code provisions again. And thankfully, we have the Carter case. We did win. So it really was a landmark victory for compassion and choice for people who are otherwise trapped in intolerable suffering. At trial, which the decision came out in 2012, the BC Supreme Court struck down the laws that prohibited assisted dying. They said they unjustifiably, this time, infringed Section 7 of the Charter. So they found the Section 7 infringement and said this time it's an unjustifiable infringement. They really, the shift in the tide of public opinion around medically assisted death was really crucial in the court coming to a different decision than what the Rodriguez court had come to. We went to the BC Court of Appeal. The BC Court of Appeal overturned that initial decision at trial and said, well, stare decisis, we have the Rodriguez decision and you're bound by that. Only the Supreme Court can overrule themselves in this matter. And thankfully, that's exactly what the Supreme Court did. They upheld unanimously the court. 9 out of 9 judges determined that the trial judge had got it right in 2012. This decision from the Supreme Court, Carter, came out in 2015. It was a really exciting day, as you can see here, the children of Kay Carter celebrating in memory of their mom. So what the Carter decision gave us, and right now as we look at challenging the constitutionality of the current federal eligibility criteria created by Bill C-14, it's really important to really focus on what did the Carter court say, because what the Carter court did is establish the constitutional floor, the minimum that has to be met in order for Canadians' rights to be respected in this context. So this is a quote from the Supreme Court. They said, "We conclude that the prohibition on physician-assisted dying is void insofar as it deprives a competent adult, criteria 1, if you will, of such assistance where the person affected, criteria 2, clearly consents to the termination of life, And the person has a criteria 3, grievous or irremediable medical condition, including an illness, disease, or disability, that criteria 4 causes them enduring suffering that is intolerable to the individual in the circumstances of his or her condition. This is a really broad right. This is anyone who's suffering from a grievous and irremediable medical condition, who's an adult, who has capacity. There was no requirement that that suffering be terminal or that people must already be dying. The case wasn't just about suffering in death or the dying process, it was equally about suffering in life. And we know that because there were plaintiffs and witnesses in front of the court on which the court made this decision that were both suffering in death and suffering in life. So current eligibility criteria are listed here, at least the ones we take issue with in the Lamb constitutional challenge that I mentioned earlier. So what we see, this is the result of Bill C-14. Individual has to have an incurable illness. They have to be in an advanced state of irreversible decline in capability, and their natural death has to have become reasonably foreseeable. Together, these mean that the longer you're going to live in intolerable suffering, the less likely you're going to be able to access medically assisted death. So really, what this case comes down to at this point is these concepts of vulnerability and choice. I would also argue has a lot to do with compassion. But just focusing on vulnerability and choice. So the government in the Sue Rodriguez case said there's too many vulnerable people. They're going to be induced to commit to end their lives. We're going to see a floodgates kind of situation where doctors are going around, killing people against their will. Essentially, we cannot tolerate this as a society. And that argument more or less won the day. With Carter, the government said the same thing. There's whole groups of people that are too vulnerable for medically assisted death to be legalized, and we're going to see them, coerced and otherwise into deaths against their will. After many experts internationally, domestically, many weeks of trial, and 4 years ultimately to get to the Supreme Court, the court in Carter determined that no, there are no groups of people that are too vulnerable. In fact, individuals are constitutionally entitled to be assessed for vulnerability on an individual basis. What we see here with the Lamb litigation is that the government's again using the same argument, which is that there are whole classes of vulnerable people, basically anyone who's not already approaching death. Those folks are too vulnerable. We simply cannot allow them access to a medically assisted death, or even to be assessed in terms of their vulnerability for it. That's, again, directly flying in the face of the Carter decision. So about 10 days, exactly 10 days after Bill C-14 came into force, Julia Lamb, who is our named plaintiff, joined BCCLA in launching a constitutional challenge to these new eligibility criteria. It was very obvious on the face of the criteria that this did not live up to the Carter pronouncement, and that whole categories of people were going to be left out, and Julia was a very obvious and immediate person who was affected. Julia has spinal muscular atrophy. She's 26 years old. It's a progressive neurodegenerative disease that causes weakness and wasting of the voluntary muscles. Ms. Lamb has been through many painful procedures, including having steel rods inserted into her back surgically when she was 7 years old in a surgery where her lungs collapsed. She has daily pain from muscle contractures. She breaks bones frequently from falling, and she experiences a lot of unfortunate physical aspects of her condition. But life is still good for Julia in many respects. She works part-time as a marketing assistant. She communicates with her loved ones. She's active in the sense that she gets around. She can drive her own electric wheelchair. She still has a certain level of control over her life. And for her, the pain has not overcome the pleasure yet that she gets from life. However, unfortunately, given her very young age, Ms. Lamb's disease could progress at any point. To the place where she's subjected to just constant severe pain instead of intermittent severe pain, where she could lose the ability, to use her hands or her arms. She would require a ventilator for assistance with breathing. She would no longer be able to speak, write, or use her computer, and she would require constant care and lose her independence in that way. Ms. Lamb could find herself trapped in a state of intolerable physical and mental suffering for years or even decades, given her young age, and she's not approaching death. Natural death. I just want to read a quote, which is partially included here, from Julia, because I think it really speaks back to that argument from the Government of Canada that there's just whole groups of people, including people with disabilities, who are just too vulnerable to be allowed to make this decision for themselves. And really what kind of disempowerment I think that reinforces. Ms. Lamb has stated, "This is about agency, choice, and compassion. This is about the most fundamental values that define being Canadian. Respecting each other's choices, even when those choices are different from one another. What I am asking for is essential to my well-being and my autonomy. I am forced to suffer with this disease without a choice, a disease that inherently limits my opportunities for choice. If my suffering becomes intolerable, I would like to be able to make a final choice about how much suffering to endure." So this is Lamb in Canada. This is the current ongoing constitutional challenge. We're arguing that the right to life is being denied or infringed or violated unconstitutionally by the effect of the legislation that was created by Bill C-14. It deprives individuals of the choice of an assisted death and leaves patients who are about to lose capacity, whether physically or psychologically, to take their own life prematurely in order to avoid suffering while they still have the capacity to do so. It violates their right to liberty. It deprives patients of a fundamental choice related to their bodies. And it also impacts the right to security of the person, of course, because of that intolerable suffering that it leaves them trapped in it and forces them to endure. So when I said earlier that I think this case is about compassion, I think choice and compassion go hand in hand. I think at a base level, everybody needs to make choices about their own body and their own lives. But I also think that you can come to the same conclusion from a place of compassion, a desire to minimize suffering and harm in the world. And this is why I want to talk a little bit about Robin Morrow. So Robin was added as a plaintiff to this case in June 21st, actually, of 2017. She came to BCCLA wanting help because she was left with the choice of death by dehydration and starvation. She was denied a medically assisted death because her death wasn't reasonably foreseeable. She knew she had very few options. She didn't want to implicate her husband in any of those decisions. And so Robin sat in her living room alone at night trying to figure out the most effective way to end her life. She described it as one of the loneliest things that she's ever done. We talked about how long it would take, how many days she might suffer before she would pass if she stopped eating and drinking. But she knew that it would still be less suffering than the death by Parkinson's. And I just want to highlight that this is where people are left by the legislation created by Bill C-14. And it's also a thank you to Dr. Alan Wiebe, who ultimately stepped up and assisted Robin's death after the AB decision came out in Ontario and clarified some of the law. But the compassion piece was still so relevant with Robin because it was just so clear with her that people aren't just weights on scales in constitutional balances. This isn't an academic exercise. It's not an exercise in balancing political interests. It's about absolutely intolerable and for many people unimaginable suffering of real Canadians and their choices. It's about awful choices that we leave people with when a medically assisted death isn't an option for them. And I had the honor of being present with Robin when she passed, or with her family, and she passed with love, with safety, with compassion, with care from all the folks around her. And it was exactly what she wanted. It was beautiful to be there to see it happen. It's really what I think everyone deserves is some control and choice at the end of their life or in the middle of life when something awful happens and you find yourself in intolerable suffering. So really everything I do on this case, Robin's now a friend, and I feel her with me whenever I get to talk about this case. So I do a lot of this work now in her memory. Thank you very much for having me here tonight. I really appreciate it. Thank you for coming.